most of my clients really don't want to proceed to court, and I understand that. So I try to work hard for clients to get them a fair and a reasonable settlement without going to court. And many times we're able to accomplish that. Sometimes we cannot. And in those cases, I recommend to folks that they proceed to court. When we reach that stage of a case, I ask people to think about what we're going to present in court, and I ask them to think about it in terms of what I call 3 chapters. Chapter 1 is what happened at the scene, the dynamics of the accident, what exactly happened, who did what, and people generally are prepared and expect to present that. That doesn't surprise them. Chapter 2, I ask people to think about and be able to present what happened to them, what treatments, what therapies they had to go through, what they had to do to get better, what their problems were, what their complaints were, what was hurting, the sequence of what was hurting, because many times it will develop 2 or 3 things, you know, after 2 or 3 other things. And so people need to know and be able to explain their path through the medical system. Chapter 3 is probably the most important part of what they lost, and that is what impact did the accident have on my client as a person affecting their life. You know, everybody is different, that everybody has their own sensitivities and sensibilities and their unique makeup, and everybody does something a little bit different to get enjoyment out of life, and that's what it's all about, living life. And so if an accident took that away from you, took something away that's important, that's precious, whatever it is, people need to think about that. I think probably juries may be more interested in that than anything else, but we want people to think about that, how they lost whatever enjoyment of life that they had, how that was taken away from them. And those are the 3 things that I ask people to think about when we're going to present a case in court.